Welcome back. Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks a Law. Driving down to Fulton Reception Diagnostic Center to meet with a client. I've got my partner Josh in the car. He's going to see a client there too. And if you're familiar with Fulton, it's home to one of the best pizza shops in central Missouri. So, I mean, look, that's lunch, man. Road trip, right? So, Josh, we've been talking about how you deal with a court ruling that goes completely contrary to what you expected and what you think is right. I mean, how do you walk out of that and console your client?
You know, there's a number of different circumstances, but that's where, in a way, we're lucky we have the rules that are supposed to govern the court and court proceedings. There's often times where those rules have been overlooked, so you can rectify stuff through actions. But there's other times that you walk out of there and there's not much you can do except for scratch your head and have a sleepless night sometimes.
Yeah, I mean, look, case in point, I just recently lost a preliminary hearing that I don't think there's any way we should have lost it. The judge ruled differently. The judge bound the case over. That's the judge's decision. It's the judge's right. But there's not really any recourse coming back from a preliminary hearing. You know, a preliminary hearing, for people who don't know, is the first opportunity to challenge the state's case. The state has to prove that there is probable cause, essentially that's more likely than not, that a felony has been committed and committed by that defendant. So it's a much lower bar than at trial. However, they still have to have some evidence of the actual fracking crime. When a ruling like in a preliminary hearing goes against you, you don't have a lot of recourse. The court that heard the case loses jurisdiction after the judge binds it over. So you can't really appeal it. Your only option is to file an objection to the preliminary hearing before you enter a plea in circuit court after the case is sent up to circuit court. In the past 7 years I've been an attorney, I've only done that once. And I'll tell you what happened. It stopped the entire court. Everybody looked around and said, well, what do we do now? Because we didn't enter a plea. We didn't say guilty, not guilty. No time standard started for anybody. I filed my objection. I said that the lower court's decision, the Associate Circuit, was arbitrary and capricious, and there was no way that a court could reasonably reach the decision to bind a case over that court did. So the judge called everybody up to the bench and said, okay, what do we do with this? And that case was set for a hearing on my objection. Well, I'll tell you, this is where the court system will screw you on something like a preliminary hearing, because instead of having the hearing on my objection and getting the case tossed, the prosecutor indicted my client and then dismissed the case that I objected in. So we're still in circuit court. Now the preliminary hearing is meaningless. So while we say that the preliminary hearing is a critical stage, it isn't really, because if it goes bad for the prosecution, or if something happens that goes bad, the prosecution is just going to indict your client and move on.
And that's where the frustration would begin and the sleepless nights begin. In the civil arena, there's different avenues early on, different pre-trial motions that can be made and done and heard by the court to dismiss counts and actions for summary judgment, And
motion reconsider a bad decision,
motion to
or a decision that you
reconsider,
disagree with.
that you disagree with, but you have to have the support to back those things up. And there is a recourse to request that the judge be removed for cause. Of course, just like all attorneys, judges have egos and they don't like to be told they're wrong. And they don't like to be the one to decide that they're wrong. And when you do a motion for a judge to recuse themselves, they actually make the determination themselves. So,
You can burn a bridge, man.
Yes.
You can burn your relationship with that judge very easily if the judge thinks that your motion is inappropriate.
Yep, and that's where it's a fine line, because the rules are set up for a reason and you're allowed to do those things for a reason. You just better be right, because you don't want to hinder further clients in front of that judge, or have to continually recuse a judge with your one right off the bat, hey, we're changing judge.
Mm-hmm. Well, there's a judge that I practice in front of, or I try not to practice in front of. I do change a judge on everything that goes in front of that judge if I can.
Yep, and it just adds more time and sometimes makes things a little bit more difficult.
Yes. But, and different attorneys do changes of judges for different reasons. When you're doing a change of judge, it could be for scheduling.
Yep.
I mean, it could only be because the other judge that you believe you're going to get scheduled is better for you than the first judge it was assigned to. Or it could be because you're judge shopping. You know the first judge is not going to be good for the case you have, and you think that the judge that will be assigned is better.
But then you always run into the other side also has their one free, hey, we're changing judges. So it's really one of the first moves on the chessboard of what is litigation.
And chess is an apt comparison too. I mean, you're comparing legal maneuvers in a chess game, and that is it right there. And it doesn't really matter, civil or criminal. Criminal is a little bit easier and cleaner. Okay, a lot of the rules are defined. The state has to play ball a certain way. If they don't, there are processes to handle that. The state's got to turn over discovery. You still have to make your request for discovery, but the state has a duty to turn it over, period. So that's a positive for the defense side in a criminal process. In the civil context, it's the Wild West, man. If you don't ask for A and you only ask for B, you're not getting A.
Absolutely. As long as the other side's attorney is doing their job right.
So, and in a criminal context, if you disagree with the judge's decision, you don't have an immediate right of appeal. You can't appeal the decision on the suppression hearing until after you've lost the case. You have to take the case through trial, lose, then you file your appeal stating that, this was an error because the judge ruled incorrectly on a suppression hearing. Unless you're the state. If you're the state, you can file an appeal immediately after the judge rules against you.
It's one way that they kind of stack the cards against you.
You think?
Yeah, but they're the ones making the rules. That's where elections have consequences.
Well, I mean, I can kind of understand that rule, though, because
I can too.
The state can't appeal from a dismissal. If the jury votes not guilty, that's the end of it. They can't appeal that.
Yep.
If the jury says guilty, you can still appeal for years. But that's the process. And I don't know about you. Well, I do know, but I'm going to ask you a question anyway. My experience is in the civil world, attorneys that are experienced in motion practice do better than attorneys that are pure law.
I would absolutely agree. One of my favorite law school professors, his favorite thing to do, and he always kept tally of how many cases he won based off of procedure and procedural motions. I would agree if you're
I'll bet it was a high
practicing that.
number.
Oh yes, and if you're practicing that and you know the rules, and you definitely have an advantage.
You know, one of our favorite facts right now, Missouri changed the rules on civil discovery. The state legislature, the Senate bill, voted to reduce the number of interrogatories that you can ask. Well, the Supreme Court had held that, it has a note in on their discovery rules that the Senate bill purports to modify that. So we didn't comply with the Senate bill right away. We actually challenged that and took it up in one of the local courts, one of our local judges. Probably, I'd say one of the more respected judges in the area. And that's not a slight on any judge. It's just that particular judge is the one that you listen to. If he says X, you give very, very serious thought to that in your practice, not only in his court but in other courts, because he is an excellent, excellent judge. That said, so we challenged that, and then we lost. I didn't get the full discovery in that case because we went over the 25 questions.
25 questions, including subparts.
Yes, including subparts. So since then, we have stopped answering anything over 25 questions. And that is and we take that challenge up before the other courts. We discuss the practice and the local practice in terms of the Senate bill that modified that. So it can be very interesting because a lot of attorneys have a set interrogatory for cases like divorce. This is what they're going to ask, and then they add all their changes that are case specific at the end. But when you have a limit of 25 and you answer the first 25 questions and subparts, sometimes that gets you like to question 13, and then you don't answer any of the rest.
So they're
stuck.
And you're not getting to the meat of that specific divorce or that specific issue because it's just generalized questions asked in the first 13, 25 with subparts.
Right. Now, and that is legal game playing. The rules allow it. And I'll be honest, there's attorneys I don't do that with. We just answer.
Yeah.
There are attorneys that are straight shooters, and they lay things out. I'm thinking of one in Kirksville. You and I have worked with him quite a bit.
Yeah, I think I know who you're talking about.
I don't play that bullshit with him because he's always been a straight shooter. Even if there was some information that he turned over discovery. He's worked as a prosecutor.
Yep.
So we just answer the questions and discuss it. Most of the cases I have with that attorney get resolved before trial because we can talk and just lay things out, and there's really no ego posturing. He is so experienced and respected in the community that he doesn't need to play that kind of crap, and it makes it so much easier because we don't have to when we're dealing with him. And you can resolve a lot of things. Now, I haven't had any of the really, really contentious ones. We have had in my firm some cases that are unreal, where people are fighting over $1 million, and it doesn't matter how good your relationship with the attorney on the other side is. You're fighting over $1 million. You've got sex abuse claims. You are doing everything you can, and that's even all the slimy lawyer tricks, right?
Yeah, absolutely.
And that's not unexpected by the hired guns that play in the field. I mean, lawyers know you're going to do what you have to do to represent your client. But you also have to be able to gauge the value of a case and what the likelihood, is this going to be rolling in the mud, or are we going to be able to work this out?
Yep.
And if you can't make that decision pretty quickly, you're going to have issues. So, turning back to the original point, when the court enters a ruling that you disagree with, you can file a motion to reconsider in civil court, and if you're going to have any kind of appeal, you have to.
Yep. It's the jumping through the hoops. You got to do step A, or else you lose step B.
In criminal court, you can also file a motion to reconsider. However, that's usually as wasted paper as it is in civil. But in criminal court, you can't appeal it until after your case is over, unless you're the state. So ultimately, everybody has a right of appeal for decisions they believe are inappropriate, as long as it is a final decision.
Yep. Both civil and criminal has to be a final decision.
Right.
There can be interlocutory orders that are appealable right away.
And that's what the state does when they're going to appeal a discovery issue.
Yep.
Now, how do you break that down to a client? When you're talking to a client in the court, you've laid out the case, you've talked all about the factors, and I'm going to come back to criminal because that's the one that's just chapping my ass right now. But you come back to all the factors, you talk about the elements, you talked about the facts, and you said, look, they can't prove this. You should win at this hearing, but you tell them, I can't make any promises. The judge is going to do what the judge is going to do. And then you lose. That's a tough situation.
Absolutely. That's one where you call up a partner, you call up another attorney right as you're leaving the courthouse saying, you won't believe what happened. And all they can do is listen.
I've been on the receiving end of those calls now.
I have been on the receiving end of those calls very recently.
Yes, you have.
And I mean, right there, you have, and we are competitive people as attorneys. I don't think you can be an attorney and not be a competitive person. So you have to vent that frustration one way or another. You have to.
Mm-hmm. And they frown on you going home and beating the dog.
That is true.
All right. Well, I'm going to end this here because we're 18 minutes in. This has been Pat Talks Law. Please hit like, subscribe, smash the alert bell too. All that. Drop a comment because YouTube seems to like it. And thank you very much for watching. We'll be back soon.